Good day, everyone, and welcome to today's conversation. My name is Eloja Taonoja, and I'm a graduate legal intern at Adun Legal. At Adun Legal, we advise startups, technology companies, and growth focused businesses on navigating the legal, regulatory, and commercial issues that arise in today's rapidly evolving digital economy. Our work spans corporate and commercial law, technology and intellectual property, financial technology and data protection, regulatory compliance, and other areas that enable businesses to innovate with confidence. It is indeed a pleasure to have you join us for this session on blockchain and cryptocurrency technology, legal, regulatory, and commercial realities for modern businesses. Blockchain has grown far beyond its origins as the technology behind cryptocurrencies. Today, it is transforming industries, reshaping business models, and prompting governments around the world to rethink existing legal and regulatory frameworks. For some, it represents the future of finance. For others, it promises a new model for ownership, commerce, and digital trust. Yet, for businesses seeking to move beyond the headlines, the conversation changes to hesitation. The excitement surrounding blockchain gives way to practical questions. First, can this business model withstand regulatory scrutiny? Second, how should digital assets even be classified? Third, what corporate structure best supports a Web3 venture? Now, these are no longer theoretical questions. They are commercial realities confronting businesses, investors, and regulators across the world. As blockchain technology continues to reshape industries, success will indeed depend not only on technological capability, but also on legal certainty, regulatory readiness, and commercially sound decision making. Today's discussion explores that intersection, and we would move beyond the hype to examine blockchain and cryptocurrency technology through the lens that matters most to modern businesses, which is the legal, regulatory, and commercial realities that determine whether innovation becomes a sustainable enterprise. Now, whether you are a founder, entrepreneur, investor, legal practitioner, compliance professional, or probably you're simply curious about the blockchain ecosystem like me, this conversation is designed to provide practical insights into the legal principles, regulatory developments, and commercial considerations that every modern business should understand before embracing blockchain technology. Now, with all that being said, let's meet our key speaker for today, shall we? Our key speaker for today is Barrister Noma, and she's a corporate and tech lawyer, strategist, and the managing partner of Adun Legal. She specializes in corporate governance, intellectual property, and legal frameworks governing emerging technology. Her practice combines business law and tech, bridging complex technical operations with strategic corporate governance, with a deep focus on intellectual property, AI regulation, data management, and corporate practice. Her core expertise is in corporate and IP, founder protections, equity structuring and startup scaling, and tech law, AI governance, data privacy, and digital assets regulation. Now, indeed, we can see that we would not have had anyone better lead us in this conversation today. Barrister Norma, we are indeed honored and privileged to have you as our key speaker for today's session. Now, Barrister Norma, can you tell us a bit about the topic blockchain and cryptocurrency technology, legal, regulatory, and commercial realities for modern businesses? And why exactly does it even matter to us, especially in today's world?
Thank you so very much, Joy, for that wonderful introduction. Truly, I could not have been better introduced. The topic today, blockchain and cryptocurrency, the legal, regulatory, and the commercial realities for modern businesses is such an interesting topic because every generation of technological advancement introduces a tool that fundamentally changes the way businesses operate. And even the internet has transformed communication and commerce. Cloud computing, for instance, redefined how organizations store and access information. Artificial intelligence that we are all battling with today in one way or the other is reshaping productivity. It is reshaping decision making. Blockchain on its own end is emerging as another foundational technology, not because it replaces any of these aforementioned innovations, no, but because it introduces a different way of establishing trust, of recording transactions, of coordinating economic activities between parties that may never meet in their entire life, all without a central authority or a third party intermediary as we know it today. Blockchain, and even though blockchain existed before Bitcoin, the first or the public first encountered and came to know blockchain through Bitcoin, the world's first decentralized cryptocurrency. And so, for many years, this technology and the digital assets built upon it were viewed almost exclusively through the lens of cryptocurrency trading and speculative investment. Now, that perception, while it is understandable, captures only a fraction of blockchain's capabilities. Today, blockchain is increasingly recognized as a digital infrastructure with applications that extend into finance, into supply chains, into healthcare, intellectual property management, digital identity, logistics, trade, finance, and even public administration. Leading organizations are also exploring blockchain to improve transparency, to strengthen data integrity, to automate commercial processes, and even reduce reliance on traditional intermediaries. This evolution, as you can see, shows a broader shift in how businesses think about value creation. Modern enterprises no longer see blockchain merely as the technology behind cryptocurrencies. Instead, they recognize it for what it is, a distributed system capable of creating shared, tamper resistant records that multiple parties can rely upon without a single central authority controlling the entire process. And in commercial relationships, especially in places where trust, verification, and auditability are essential, blockchain represents an alternative model to manage these informations and execute transactions seamlessly. And so we find that over the years, as blockchain has matured and even the various uses of blockchain, its commercial significance also has become more evident. Financial institutions are now investing in tokenized assets and digital settlement systems. Manufacturers are deploying blockchain solutions to improve supply chain visibility. Logistics companies are using distributed ledgers to enhance traceability. Intellectual property owners are exploring blockchain based systems for licensing their intellectual properties and even managing their royalties and all the many fees that come from the use of their IP. Governments and regulators are examining its potential in areas such as digital identity, land registrations, and registry management, and even the public records. So these developments all together, they demonstrate that blockchain is no longer confined to experimental projects, so to speak. It is steadily becoming part of mainstream business today. Yet, as we know with everything else, technological capacity alone does not determine commercial success. So every meaningful innovation eventually encounters legal, regulatory, and governance questions. And blockchain is no exception because as businesses integrate digital assets, tokenized ecosystems, and decentralized applications into their operations, they must navigate issues relating to securities regulation, corporate governance, data protection, taxation, contractual liability, anti-money laundering, and all these other obligations that come with the use of blockchain and any kind of technology really that transcends geography. And so the legal implications of the use of blockchain, especially in a business setting, extends well beyond cryptocurrency and it touches on virtually every stage of a blockchain enabled business model. This explains why discussions about blockchain have become more and more sophisticated and more complex because the central question is no longer whether blockchain has potential. We know that it has potential. The question now is whether or not businesses are asking if or the question now is whether or not businesses are deploying it responsibly, are complying with evolving regulatory requirements, and they are building commercially sustainable models that inspire confidence amongst all of your stakeholders, whether that be investors, customers, the government, financial institutions, or regulators alike. And you can find now that, as your success increases as a blockchain based business, it depends more on aligning your technological innovation with sound legal frameworks, effective governance, and commercially practical decision making. And so I think that, against this entire backdrop is what our conversation today, blockchain and cryptocurrency technology, the legal, regulatory, and commercial realities for businesses. I think this is what it's based on, an in-depth understanding of every single thing really that has to do with blockchain, whether it's the legal principles that govern digital assets or the regulatory frameworks that shape blockchain markets across the globe and across the different regulatory jurisdictions, and the commercial realities that will determine whether or not your blockchain based venture will thrive in the market or will struggle. And so when you understand how these dimensions work together, both the legal, the commercial, and the regulatory, you can then begin to see how you as a business can participate confidently in such an evolving or in such a rapidly evolving digital economy.
That was an interesting one. So, Barcelona, having understood this introduction, now we often limit blockchain to only cryptocurrency. So, we'd like to know what exactly is your take on this, and does blockchain transcend Bitcoin and other cryptocurrencies?
Well, despite the widespread attention blockchain and Bitcoin receives, blockchain remains one of the most misunderstood technologies in modern businesses. Much of this understanding stems from the tendency really to equate blockchain with cryptocurrencies like Bitcoin and Ethereum and other cryptocurrencies like that. And while these cryptocurrencies are amongst the most recognized use of a blockchain, blockchain technology itself is the underlying technology that enables far more than the transfer of digital currencies. It is a form of a distributed ledger technology that records, verifies, and stores transactions across a network of computers in a manner designed to promote transparency, integrity, and resilience. And unlike with traditional databases as we have them, where a single organization, like a bank, for instance, maintains and controls the record, a blockchain distributes identical copies of its ledger across multiple participants in a network. So each new transaction is validated through an agreed consensus mechanism before being added permanently to the chain of existing records. And once recorded, information contained in a blockchain cannot be altered without the entire or without the agreement of the network, as it were, making that ledger highly resistant to unauthorized modification. This combination of decentralization, transparency, and immutability enables participants who may not know or trust one another to transact with even greater confidence, thus reducing dependence on central intermediaries for verification. And this distinction is very, very important because blockchain should be viewed as digital infrastructure rather than simply a financial innovation. In fact, if anything, I would personally say that trying to box it into simply a financial innovation is doing a disservice to the entire or to the entirety of blockchain technology as well. So just as the internet became the infrastructure for email, e-commerce, social media, and etc., blockchain is increasingly becoming the infrastructure for recording ownership, for transferring value, for verifying identity, and for automating commercial relationships. Cryptocurrency is simply one application built on blockchain, not the technology's defining purpose. And so when you understand this distinction, it would allow you, especially as a business, to evaluate blockchain based on the commercial problems it can solve for you and for the market rather than the volatility that is associated with other digital currencies like Bitcoin, Ethereum, stablecoins, and so on and so forth. So these commercial applications of Bitcoin, as you have clearly seen, can extend across a wide range of industries, not simply financial. In financial services, yes, blockchain supports faster settlement, tokenization of financial assets, and even cross-border payment. Financial institutions, which again is one of the most popular uses of a blockchain, are now investing in tokenized stocks, in bonds, and in other real-world assets as part of a broader transformation of the capital markets, if I am permitted to explain it that way. But beyond finance, blockchain is also improving supply chain management by creating transparent and verifiable records of products as they move from manufacturers to distributors and then to the end customers or the consumers. Businesses can, using blockchain, trace the origin of goods, they can verify authenticity, they can strengthen quality assurance, they can even respond more efficiently to recalls or to compliance requirements. And for an industry where provenance, sustainability, and consumer trust are commercially significant, blockchain provides a shared record that enhances this visibility across multiple stakeholders. Not only in the logistics industry and in the finance, blockchain is also transforming digital identity management. Now, instead of repeatedly submitting your personal information every single time to different organizations, individuals may hold verifiable digital credentials that can then be securely shared while retaining greater control over their personal data. Similarly, innovations are emerging in intellectual property management, where blockchain enables creators to establish verifiable ownership records, monitor licensing arrangements, and improve royalty distribution. In logistics, in healthcare, and even in public administration, distributed ledgers are being explored to strengthen record keeping, improve operational efficiency, and reduce opportunities for fraud. Another significant development of blockchain, which we'll talk about much later in depth, is the rise of smart contracts, self executing computer programs that automatically perform contractual obligations once predetermined conditions have been satisfied. By reducing this manual intervention of actual manual contracts, smart contracts have the potential to increase efficiency, to minimize delays, and to lower transaction costs across a variety of commercial relationships. However, they also important legal questions concerning contractual interpretation, liability, dispute resolution, and regulatory compliance. Issues that businesses really must address before deploying any blockchain based solution at scale. And so, as the adoption of blockchain continues to mature, business are moving beyond experimentation to more toward enterprise implementation. This conversation, or the general conversation, really shifts from whether or not blockchain has practical value to identifying where it creates measurable commercial advantages and how it can be integrated into existing governance and compliance frameworks. Organizations are also evaluating blockchain not as a replacement to any existing system, but as a tool capable of improving trust, improving transparency, efficiency, and collaboration where multiple parties must share reliable information. And so, generally, understanding blockchain as a business infrastructure will also explain why regulators have devoted increasing attention to digital assets and other such currencies. And once blockchain began facilitating the creation of cryptocurrencies, tokenized assets, decentralized finance platforms, and other new ways of raising capital, an important legal question emerged. What exactly are these digital assets in the eyes of the law? Now, the answer to this question it determines which regulatory framework applies, what licenses will be required, the rights attached to the assets, and the obligations imposed on those who issue, trade, or invest in it, and every single thing that applies to that.
This really sounds interesting. Let's explore this question of classification. So, what exactly are these digital assets in the eyes of the law, and why does classification determine everything?
Well, classification determines everything because as blockchain technology has evolved beyond its original use case, regulators around the world have also been confronted with a fundamental legal question, which is what exactly is a digital asset? As deceptively simple as this question appears, its answer determines the legal obligations of both the issuers, the rights of the investors, the powers of the regulators, and the compliance responsibilities of every business operating within the blockchain ecosystem. Now, you can see how complex the question or the answer to this question is. And now, before any regulator can now even determine which rules apply, it must first determine what exactly it is regulating. it is regulated. So therefore, classification sits at the heart of blockchain regulation and serves as the starting point for any legal analysis, which thankfully we are here to do. But first of all, a common misconception is that all cryptocurrencies are legally identical because they are created using blockchain technology, or they are run or they function based on the underlying blockchain technology. In reality, digital assets perform different economic functions and they confer different rights on their holders. Consequently, regulators do not classify them based on the technology that underpins them, but on their characteristics, on their purpose, and on the rights that they create, and even on the obligations that they evoke in their rights issuers and their developers, and even the companies that run them. And so in law, substance prevails over form. Simply describing your digital asset as a token or as a cryptocurrency does not determine its function in law or its legal status even. What matters is how that asset functions, how that asset is marketed, and the expectations created for those who acquire said asset. Broadly speaking, digital assets may be grouped into several categories. The first is cryptocurrencies such as Bitcoin, which primarily functions as a medium of exchange or as a store of value within the centralized network. Another category consists of utility tokens, which grant holders access to a product, a service, or a blockchain ecosystem without necessarily conferring ownership or investment rights. Stable coins are designed to maintain a relatively stable value by referencing another asset, such as maybe a fiat currency, etc., making them particularly useful for payments and settlement. Another is a non-fungible token, or you know another type of token, which represents unique digital assets and have found use cases or applications in art, in gaming, entertainment, and intellectual property as a whole. Finally, there are also security tokens, which are all grouped as part of a token, which represents ownership interests or investment rights, similar to a traditional financial instrument such as like shares, bonds, bills, etc. Each of these categories raises its own legal and regulatory consideration. Now, among these categories, both the utility tokens, the non-fungible tokens, and the security tokens attract the greatest regulatory scrutiny because they closely resemble traditional investment instruments. So if a token gives its rights holder, or if a token gives its holder rights comparable to equity ownership or debt obligation or even dividend participation, profit sharing, or other investment interests, regulators are likely to subject it to securities regulations regardless of the underlying technology to which those rights are recorded or which enables those rights to function. In other words, placing an investment instrument on a blockchain does not exempt it from existing financial laws. Blockchain changes the method of issuance and record keeping. It does not alter the legal nature necessary for an underlying asset to function or to be regulated. This now is where the distinction between token economics and securities law becomes particularly relevant, because token economics, commonly referred to as tokenomics, examines how a digital asset is designed to function within a blockchain ecosystem. It considers matters such as token supply, distribution, incentives, governance mechanisms, and utilities within the network. Securities law, by contrast, is concerned with investor protection, market regulation, market integrity, and financial regulation, as it were. A token may have a sophisticated economic design, but if purchasers are led to invest with the expectation that others will generate profits for them, regulators will conclude that the transaction falls squarely within securities legislation, irrespective of the technical architecture or of the underlying technology of that token. And so historically, one of the most influential legal standards in this area has interestingly been the Howey test, developed by the United States Supreme Court in Securities and Exchange Commission versus W.J. Howey Co. Under that framework, an arrangement may constitute an investment contract where there is an investment of value in a common enterprise with a reasonable expectation of profit derived from the managerial or entrepreneurial efforts of others. And although this test originated decades before blockchain technology existed, it has even now significantly influenced the legal assessment of digital asset offerings and continues to shape discussions on crypto asset regulation internationally. And so you can see now the importance of classification and why understanding the base functionality of any cryptocurrency, whether it's a token or an actual cryptocurrency, and properly classifying it matters, because not only does it carry legal consequences, it also carries commercial consequences. Because if a digital asset is treated as a security, its issuer may be required to register offerings, make prescribed disclosures, comply with licensing requirements, and adhere to continuing regulatory obligations. Failure to classify a token correctly can then expose your business, not just your own business, but also that of the issuers, to enforcement actions, to financial penalties, to investor claims, and even reputational damage. Conversely, where a digital asset performs a genuine consumptive or payment function without creating investment rights, a different regulatory framework may then apply. And so for businesses, classification is not merely a legal exercise. It is a strategic business decision that influences your fundraising, your product design, your governance structures, and your market entry, aka your bottom line. And so an even additional layer of complexity will then arise because jurisdiction does not always offer digital assets or does not always classify digital assets in the same manner. A token that is regarded as a payment instrument in one country may be regulated as a financial product in another. Some jurisdictions have even introduced bespoke legislative frameworks for crypto assets, while others continue to apply existing financial securities and consumer protection laws. As blockchain businesses increasingly operate across borders, navigating these divergent approaches has become one of the defining challenges of the digital economy. And so, understanding classification is therefore about more than attaching a label to your digital asset. It is about identifying the legal consequences that flow from those labels and recognizing that regulatory compliance begins long before any token is ever issued or traded.
Yes, I actually see where you are going with the importance of classification. Once a business understands what its digital assets represent in law, it can then begin to navigate the broader regulatory landscape with greater confidence. And we know that each country has its unique perspective on blockchain and cryptocurrency, and it is just as important to know each major player so that we can understand just how they apply to businesses and consumers within the blockchain and crypto niche. Could you please shed more light on this regulatory landscape?
Oh, okay. So once a digital asset has been properly classified, the next challenge naturally is determining which regulatory framework governs its issuance, its trading, and its use. This is where blockchain businesses encounter one of the defining characteristics of the digital economy, which is that blockchain networks that operate across borders, which is generally that blockchain networks operate across borders while legal systems remain territorial. A blockchain transaction can involve participants in multiple jurisdictions, each applying different regulatory standards. As a result, your business cannot assume that compliance in one country automatically satisfies the requirement in another. This cross-border regulatory awareness has therefore become an essential component, really, of building any sustainable blockchain-based business. The global regulatory conversation, as we said earlier, has matured in the last decade. Early regulatory responses were largely reactive, and naturally so because the technology evolved faster than the laws could catch up. But today, the objective has broadened. Policymakers increasingly recognize that blockchain technology has legitimate commercial applications capable of driving innovation, improving financial infrastructure, and even expanding digital commerce. The focus has therefore shifted toward developing regulatory frameworks that encourage responsible innovation while safeguarding market integrity, financial stability, and consumer confidence. Let's talk about now. Let's talking about the countries individually. The United States, for instance, remains one of the most influential jurisdictions in shaping global regulatory conversation. Rather than creating a comprehensive standalone statute for crypto assets, the US regulators have generally applied existing securities, commodities, and financial services laws to blockchain activities. The Securities and Exchange Commission (SEC) has consistently maintained that where a digital asset functions as an investment contract, it falls within the scope of the federal securities laws, regardless of the technology used to issue or transfer it. This approach leads or has led to a significant enforcement activity against issuers, exchanges, and other market participants that have failed to comply with these securities regulations. And for businesses seeking access to the United States market, regulatory analysis must therefore begin with a careful assessment of whether or not your product or service falls within SEC's jurisdiction. In contrast to the United States, the European Union has adopted a more unified legislative framework through the Markets in Crypto Assets Regulation, the MiCA. MiCA establishes harmonized rules for crypto asset issuers and crypto asset service providers across the EU member states, thus reducing regulatory fragmentation within that singular market. It also introduces requirements relating to authorization, governance, consumer disclosures, prudential safeguards, and operational resilience, while providing dedicated rules for asset reference tokens and electronic money tokens. By replacing these multiple national approaches with a common regulatory standards, the MiCA applicable in the EU offers businesses greater legal certainty when operating across the entire European Union. The UK has adopted a different, though increasingly comprehensive approach because they built upon earlier anti-money laundering registration requirements and financial promotion rules in the UK, and they have introduced, using those rules as a foundation, a broader regulatory regime that brings a wide range of crypto asset activities within the supervision of the Financial Conduct Authority or of the FC. This framework places a significant emphasis on authorization, prudential standards, consumer protection, market integrity, and operational resilience. And so firms that are intending to provide regulated crypto asset services in the United Kingdom must prepare to satisfy the same standards expected of participants in other regulated financial markets. Coming to Nigeria, we have likewise taken significant steps towards developing a coherent framework for blockchain technology and digital assets, because recognizing blockchain as a strategic driver of economic growth and digital transformation, the Federal Ministry of Communications, Innovations, and Digital Economy has then introduced several policies, key among them or chief among them being the National Blockchain Policy for Nigeria in 2023. The policy provided a national roadmap for blockchain adoption across key sectors of the economy, including finance, identity management, healthcare, supply chain, education, and public administration, while promoting innovation, collaboration, and even responsible governance. And so, complementing this policy direction, which the National Blockchain Policy for Nigeria, the Securities and Exchange Commission also established a regulatory framework for digital assets and virtual asset service providers, including rules to govern digital asset offerings, exchanges, and custodians. More recently, the Investment and Securities Act of 2025 recognized digital assets and expanded SEC's statutory authority to regulate these digital asset securities and related service providers. together with anti-money laundering obligations, data protection requirements under the Nigerian Data Protection Act, evolved and the Central Bank of Nigeria's evolving risk-based approach to banking relationships with licensed virtual asset businesses. These developments altogether reflect Nigeria's commitment to fostering blockchain innovation while still safeguarding market integrity, financial stability, and even investor confidence. And not even just these two things. Nigeria's regulatory landscape has continued to evolve beyond legislation and policy development. Just this month, in July 2026, the federal government of Nigeria established the Virtual Asset Council, the VAC, through an executive order to strengthen regulatory coordination within the country's digital asset ecosystem. Now, this council serves as a multi-agency platform to bring together key regulators and stakeholders to promote a coherent and innovation-friendly approach to the virtual asset regulation. But we won't go into much about what the Virtual Asset Council is about and what they do. We can take that up at a later date. But together, combined with all, together, whether it's the National Blockchain Policy for Nigerians, whether it's the Investment and Securities Act of 2025, or even this new Virtual Asset Council, all of these approaches illustrate, not even just in Nigeria, but also in the US, in the UK, and in the EU, and many other countries that we did not mention here. They illustrate that there is no single global model for regulating blockchain technology. And while some of these jurisdictions rely primarily on existing financial or securities laws, others have enacted their own legislation or even adopted national policy frameworks that encourage responsible innovation. And so for these blockchain businesses, this fragmented regulatory environment presents a practical operational challenge because, we have the EU here, we have the UK, we have the US, we have Nigeria, and all of these countries operating individually or independently. Now, you can see how that would create an operational challenge for any business, especially one in an industry that is cross-border or in an industry that is global, where it's like a token issued in one jurisdiction may be marketed to users in several others, thus imposing different licensing requirements, disclosure obligations, or even taxation rules, consumer protection standards, data protection rules, etc. on these businesses. And as a business, you must evaluate not only where you are incorporated, but also where your users are based or where you plan to run your business operationally, because compliance consequently becomes a continuing business function rather than a one-time legal exercise that is completed at the point of launch or and the worldwide expansion, of these blockchain regulations. Because you can even find now that these regulations have begun to affect investment decisions because we have, institutional investors, commercial banks, and strategic partners placing greater emphasis on regulatory readiness before committing capital or entering any kind of commercial relationship. That's just to show you the importance of understanding not only where you are incorporated, but also where your users live and where you plan to operate and the laws that guard or that govern these places.
Now, so that means demonstrating robust governance, transparent compliance procedures, and proactive engagement with regulators can significantly strengthen a blockchain company's credibility, improve access to financial service, support long-term commercial growth, and other such benefits. Now, naturally, this begs the question, how does one build a blockchain-based business the right way?
Whew. How does one build a blockchain business the right way? What a stunning question. Um, well, okay, let's take it this way. Once a blockchain business understands the regulatory environment in which it intends to operate, the next question, which is, how should the business itself be structured, is also as important, which you have clearly pointed out. So, one of the Consequently, one of the earliest and most consequential decisions for any Web3 venture is selecting a legal structure that supports innovation while providing legal certainty and commercial credibility. In the early years of blockchain development, many projects prioritized technological innovation and community growth without paying comparative attention to legal structure. Some even launched tokens before incorporating a company, while others attempted to operate entirely through decentralized online communities. Experience has demonstrated that this approach creates significant legal and commercial challenges, and without a recognized legal entity, projects may struggle to open bank accounts, to be or have the rights of an artificial person, to negotiate commercial contracts, to employ personnel, protect their intellectual property, engage institutional investors, and many benefits that come with having a registered entity. More significantly, founders and active participants may become personally exposed to legal liabilities that would ordinarily be borne by the company, which would be an or which is an artificial person. For this reason alone, many successful Web3 projects adopt structures, corporate structures that separate different aspects of the business from their person, or even separating this, or having an operating company that manages product development, recruitment, commercial partnerships, and day-to-day operations, and even where appropriate, they can have a separate foundation or a similar entity to oversee protocol development or ecosystem stewardship, while their digital tokens operate as distinct components of the broader project rather than replacing the digital or the legal entity itself. Because let's face it, blockchain projects introduce an additional layer through digital tokens, which may provide access to a platform, governance rights, economic incentives, or even participation within a decentralized ecosystem. These two forms of ownership, aka having a legal entity, a profit making legal entity or a for profit entity to manage the business itself, and having a foundation to manage the ecosystem and the community, should not be identical and are not even identical. Holding a project token does not necessarily make an individual a shareholder, just as owning shares does not automatically entitle an investor to governance rights within a decentralized protocol. So it's important that you distinguish between these two things. This distinction becomes even more significant when projects evolve towards decentralized autonomous organizations, or a DAO. Now, a DAO seeks to replace traditional hierarchical management with governance mechanisms embedded in smart contracts, thus allowing members to propose and vote on decisions collectively. This model has introduced new possibilities for global collaboration by enabling geographically dispersed participants to coordinate without conventional corporate management structures. Nevertheless, decentralized governance does not eliminate legal responsibility. Someone must still enter their contracts. Someone must still manage your intellectual property, must still satisfy regulatory obligations, and represent the company or the project in dealings with financial institutions, service providers, and even the courts if it comes down to that. And while your code can automate many of the operational processes, you cannot eliminate entirely the legal relationships that are recognized by national legal systems. And so the legal status of a decentralized autonomous organization remains one of the most closely examined issues in any Web3 governance. Courts and regulators are increasingly or have increasingly demonstrated that describing an organization as decentralized does not necessarily shield its participants from legal responsibility. Where no recognized legal wrapper exists, active participants or governance token holders may, depending on the applicable jurisdiction and the factual circumstances, face arguments that they are operating as an unincorporated association or a general partnership, thus exposing them to personal liability for the organization's obligations. And so this evolving legal landscape has encouraged many blockchain projects to combine decentralized governance with formal legal entities capable of interacting with the traditional legal and financial systems. And so naturally, corporate governance extends far beyond selecting the appropriate legal entity. It also requires clearly defining how these decisions are made, who exercises authority, and how conflicts of interest are managed, and even how accountability and transparency is maintained within the organization and with your stakeholders. And so as a blockchain-based business or even one running a blockchain project, you must determine the respective roles of your founders, of your developers, the token holders, the investors, and the governance bodies or the governance bodies, while establishing transparent procedures for treasury management, protocol upgrades, voting processes, risk oversight, and all these other aspects of a traditional commercial entity. Intellectual property is also another foundational consideration that should be addressed at the structuring stage. And although blockchain technology promotes decentralization, valuable intellectual property, whether that is your software code, your trademark, your copyright, your documentation, your proprietary, knowledge, etc. They must still all be owned, be licensed, and managed appropriately. So business should establish clear ownership arrangements from the very beginning, particularly where development involves distributed contributions across multiple jurisdictions. Because failing to define these roles or failing to define these rights on time will create uncertainty regarding the commercialization, the licensing, the future investment, and the acquisition opportunities that your business, your blockchain-based business, and even your intellectual property will face. So, in essence, corporate structuring is not merely an administrative requirement. It is a strategic decision that shapes the future of the enterprise because investors assess governance before even providing capital. Financial institutions evaluate organizational legitimacy before establishing banking relationships. Regulators consider legal structures when determining compliance obligations. Commercial counterparties seek certainty regarding who bears the responsibility for contractual commitments. And so you can clearly see that a thoughtfully designed structure therefore enhances your credibility, it facilitates your growth as a business, and it reduces the legal risks that your business will be faced with or will likely encounter as it grows and gets bigger.
Wow. So that means a thoughtfully designed structure is key to all these benefits. Now, commercially, what does that look like for a blockchain based business? I mean, what are the commercial realities they must understand? Because in the end, the goal of any business is commercial success.
Well, yeah, a well designed blockchain project may be technologically impressive and even legally compliant, and yet they will still struggle if they cannot overcome the commercial realities of operating in the marketplace. And this commercial success, it depends not only on your technological innovation, even though that is very, very important, but it depends also on your organization's ability to access financial services, to raise capital, to manage operational risks, and even build trust with your stakeholders. And so, as the blockchain industry has matured, these commercial considerations have become just as significant as the underlying technology itself. One of the earliest commercial challenges that many blockchain businesses encounter, especially when starting newly, is establishing and maintaining banking relationships. Financial institutions play a critical role in enabling businesses to receive payments, to send payments, to pay employees, to manage operational expenses, and even to interact with the broader financial system. And so, despite the increasing acceptance of blockchain technology, many financial institutions continue to subject crypto related businesses to enhanced due diligence because of concerns surrounding anti money laundering compliance, sanctions exposure, fraud risks, and even regulatory uncertainty. And so, as a result, businesses seeking banking services must demonstrate robust governance. They must demonstrate transparent ownership structure, effective compliance programs, and comprehensive risk management procedures before financial institutions are willing to establish any long-term relationship with them. Fundraising presents another defining commercial consideration. Blockchain has introduced new methods of raising capital beyond conventional venture financing. And while traditional equity investment remains an important source of funding, many Web3 projects also explore token-based fundraising mechanisms that enable participation within their broader ecosystem, even from community members and not only institutional investors. And so, regardless of the fundraising model adopted, investors increasingly evaluate projects through the same commercial lens applied to any emerging business. They examine the competence of the management team, the sustainability of the business model, the governance arrangements that they have in place, the regulatory compliance, and whether or not you have actually complied with them, your cybersecurity preparedness, and the practical utility of your offering or of your technology. And so, while your innovative technology may at the start attract interest, long term investment decisions are driven by confidence in your project's ability to execute responsibly within, and this is very important, your project's ability to execute responsibly within an evolving legal environment. This commercial scrutiny has significantly influenced how blockchain businesses approach token economics. Designing a token is no longer simply about, it's no longer simply a technical exercise involving supply, distribution, and network incentives. No, businesses must ensure that their token structures support genuine commercial activity rather than encouraging purely speculative behavior. And so, investors and regulators alike, they are distinguishing now between projects whose tokens perform meaningful functions within an operational ecosystem and those whose value proposition depends primarily on expectations of a future price appreciation. And so, financial management as a whole also assumes greater complexity within a blockchain business because treasury management now extends beyond simply holding cash in a conventional bank account to managing digital assets that may experience significant price fluctuations. And as a business, you must develop an internal policy to govern custody arrangements, liquidity management, diversification strategies, cybersecurity controls, and financial reporting. And decisions that regard these things, whether or not to retain digital assets, to convert them to fiat currency, or even to deploy them within a decentralized finance protocol, requires careful consideration of market conditions before they are even made. It requires careful consideration of not only market conditions, but also of operational needs and organizational risk tolerance, aka what it is that your organization can tolerate. And an effective treasury management within your organization will then help your business with its strategic growth objectives. Taxation is another thing. While we've dealt with finance, we've dealt with fundraising as part of the commercial realities that any blockchain-based business must understand. Taxation is another thing because while tax treatments differ across the various jurisdictions, blockchain transactions can generate multiple tax consequences simultaneously, depending on the nature of the activity involved. The issuance of tokens, the disposal of digital assets, the staking rewards, the mining activities, decentralized finance transactions, cross-border transactions, etc. All of these things individually and together can trigger distinct reporting and tax obligations. And so, as a business, you should integrate tax planning into your product design and operational decision making rather than treating tax as an afterthought or treating tax as something you handle only when you've made some kind of profit. That's the wrong approach. And so commercial relationships within outside finance, outside fundraising, outside taxation, your commercial relationships between your stakeholders, whether they are within the blockchain ecosystem or not, also depends again on the beauty of your carefully crafted commercial engagement or your contractual engagements. Technology does not eliminate the need for legal agreements. No, Instead, it increases the importance. Because businesses routinely enter contracts with software developers, infrastructure providers, custodians, exchanges, payment processors, cloud service providers, strategic partners, enterprise clients, etc. And these agreements allocate responsibility, establish service standards, it defines intellectual property ownership, it regulates confidentiality, and it provides mechanisms to resolve these disputes. And so you need contracts. An additional an additional commercial consideration is the integration of smart contracts into your business transactions, because you can't really talk about cryptocurrencies based on the blockchain without talking about smart contracts, really and truly. And so smart contracts will help you to automate payments, asset transfers, and other obligations with remarkable efficiency, really. But we're not talking about smart contracts now, so we're just going to move on. Another commercial reality of a blockchain business is risk management, because it is central to every commercial decision within the blockchain industry. Cybersecurity threats, operational failures, regulatory developments, market volatility, technological vulnerabilities, and even reputational risks, all of these have the capacity to affect your business continuity. And so, resilience as an organization requires you to establish comprehensive governance frameworks that address each of these realities, each of these commercial realities, from taxation to fundraising to financial management to community management to relationships to contracts. You need complete, comprehensive governance frameworks that help you manage all of these. And so ultimately, commercial success in the blockchain economy is not determined solely by technological innovation or even regulatory compliance. No, it is achieved by integrating sound governance, prudent financial management, strategic fundraising, effective contractual arrangements, and disciplined risk management into a coherent business strategy. Because blockchain businesses that appreciate this broader commercial view are significantly better equipped to move beyond early stage innovation and establish durable enterprises capable of thriving within an increasingly global marketplace.
Wow, I must say, you keep raising really interesting threads for us to follow, because when commercial relationships are increasingly executed through software rather than traditional documentation, then the issue of responsibility and liability immediately arises. So, how does the law allocate responsibility when something goes wrong? And for that, I think we need to talk about smart contracts, the legal enforceability and liability as well. So, what do you think?
I think that I should stop talking because I keep raising things for us to talk about, and I don't know if we have all that time. But anyways, to answer your question on smart contracts, yeah. So as blockchain technology continues to reshape commercial transactions, one of its most significant innovations is smart contracts. And despite its name, a smart contract is not necessarily a legal contract in the traditional sense that we know contracts as. Rather, it is a computer program deployed on a blockchain that automatically executes predefined actions when specified conditions are met. It can transfer digital assets, it can release payments, it can record ownership, or even trigger contractual obligations without requiring continuous human intervention. And this capacity for automation has made smart contracts a powerful tool for improving efficiency, for reducing transaction costs, and for minimizing reliance on intermediaries. At the same time, it has also introduced a new set of questions or a new set of legal questions that businesses cannot afford to overlook. The defining characteristic, as I mentioned earlier, of a smart contract is that it performs obligations automatically. And once deployed, the code executes according to its programmed instructions. This creates a greater certainty in routine transactions because performance is driven by objective conditions rather than the manual processes which are prone to error. So for businesses, the commercial advantages are substantial because payments can be released immediately once contractual obligations are fulfilled. Supply chain events can trigger automated settlements. Token transfers can occur instantly upon satisfaction of agreed conditions, and even administrative costs associated with monitoring contractual performance can be significantly reduced. Sorry about that, guys. These inefficiencies explain why smart contracts are increasingly being incorporated into financial services, insurance, trade, finance, digital markets, or digital asset markets, and even supply chain management, as it were. Automation, however, should not be confused with legal enforceability. A smart contract may perform or may execute perfectly from a technical standpoint and yet still fail to satisfy the legal requirements for a binding contract. In most legal systems, enforceability depends on established principles of contract law, which includes offer, acceptance, consideration, capacity, and intention to create a legal obligation or even a legal relation, and the certainty of the terms. Computer code alone does not establish these elements. Consequently, businesses should avoid assuming that every blockchain transaction will necessarily be recognized as legally binding simply because it was executed by software. This distinction has encouraged many organizations to adopt a layered contractual approach. And rather than relying exclusively on code, businesses combine a traditional written agreement with smart contracts. And so the written agreement sets out the commercial bargain, it allocates the legal responsibility, it even specifies the governing law, establishes the dispute resolution procedures, addresses circumstances that can easily or establishes the dispute resolution procedures and addresses circumstances that cannot very easily be established or be translated onto software. And so the smart contract then automates the defined aspects of performance while the legal contract manages the aspect of enforceability. This approach allows a business to benefit from technological efficiency while preserving the legal certainty associated with conventional contractual documentation. Another important aspect really is contractual interpretation. Traditional contracts are drafted in natural languages, thus allowing courts, arbitral tribunals, and even third-party laymen in code to interpret ambiguous provisions in light of the parties' intentions and the surrounding commercial circumstances. Smart contracts, on the other hand, operate according to computer code that executes with precision, regardless of whether the commercial outcome reflects the party's intents or not. This has given rise to the well known debate over whether code is law. In practice, neither proposition is entirely satisfactory. Code determines how a software behaves, while the law determines the legal rights and obligations of the parties. Businesses therefore need both technical accuracy and legal clarity to minimize disputes that arise as a result of any of these things to do with a blockchain-based business. Another complex challenge when dealing with smart contracts is the issue of liability. When a smart contract produces an unintended outcome, identifying the responsible party is very rarely straightforward. Responsibility may potentially involve software developers, platform operators, protocol administrators, business protocol administrators, and even any other kind of person so connected within that ecosystem. And so businesses deploying smart contracts, etc. The answer therefore depends upon the contractual arrangement, the applicable regulatory framework, and the factual circumstances surrounding the transaction itself. So clear allocation of responsibility through carefully drafted traditional agreements is therefore essential to reducing legal uncertainty and managing commercial risk. Many smart contracts also depend upon external information to function effectively because blockchain, Blockchain technology or even blockchain itself cannot independently verify real world events. They rely on trusted data provided by they rely on trusted data providers to supply information to them, such as the exchange rates, the weather condition, the shipping confirmation, or even the market prices. And while these trusted data providers, known as oracles, significantly expand the practical use of smart contracts, they also create additional risk. Because if any information that they give is inaccurate, is delayed, or is somewhat manipulated, the smart contract will still execute its obligations precisely as programmed while still producing an incorrect commercial outcome. And so, as a business, you must evaluate the reliability, the governance, and the accountability of your trusted data providers as carefully as you would evaluate the underlying software itself. Then we have consumer protection and regulatory compliance, because at the end of the day, automation does not exempt a business from regulatory obligations related to disclosure, fairness, privacy, anti-money laundering requirements, or even financial regulation. And so where your consumers interact with blockchain applications, your business must remain responsible for ensuring that contractual terms are transparent, that users understand the legal implications of their actions, and that mandatory legal protections continue to apply regardless of the plane within which it's meant to apply. And now, a technologically sophisticated platform that disregards these obligations will expose its operators to regulatory enforcement and even civil liability, notwithstanding the automated nature of its transaction. And then another issue that smart contracts have to contend with is cybersecurity. Smart contracts, once they are deployed, are immutable unless they have been deliberately designed with upgrade mechanisms. And so, therefore, a programming error or even a security vulnerability can have immediate and substantial financial consequences. High profile blockchain incidents have demonstrated that coding flaws may result in the loss of unauthorized transfer of digital assets within a very, very short period. And so, as a business, you should invest in rigorous code reviews, in independent security audits, in penetration testing, and in continuous monitoring before deploying any smart contract in a commercial environment. This risk management should begin during system design rather than after deployment. And even disputes, I mean, I know that we've talked about a whole host of things from a whole host of things, really. Let's not go back to start calling them. But I know that we've discussed a whole host of things. And even disputes involving smart contracts require careful planning. So, not just cybersecurity, not just consumer protection, not just contractual interpretation, not just the relations, even disputes, something as small or as big as disputes, require careful planning, because automated execution alone does not eliminate disagreement. Instead, it changes the nature of the disputes that arise. Because now you now have questions like, oh, what about the coding defects? What about mistaken transactions? What about inaccurate Oracle data? What about contractual interpretation, jurisdiction, applicable law, etc.? These all require determination by courts or arbitral tribunal or even any other ADR mechanism. For this reason alone, your business should include clearly drafted dispute resolution clauses, governing law provisions, and mechanisms for addressing technical failures within their broader contractual framework, whether that be in the smart contracts or that be in the traditional legal contracts that you have. So ultimately, smart contracts should be viewed as a tool that enhances commercial transactions rather than something that will replace traditional contracts or that will replace the law. And because, while smart contracts automate performance, improve efficiency, and reduce operational friction, they do not reduce or remove the need for sound legal drafting, effective governance, or even prudent risk management. So, businesses that integrate legal expertise into the design and deployment of any smart contract system is better positioned to harness the benefits of blockchain technology while mitigating the legal and commercial risks that accompany automation.
Wow, we've really had an insightful one so far. Understanding this legal and operational risk naturally leads to a broader strategic question. Beyond complying with existing laws and managing contractual liabilities, how exactly can businesses, position themselves to thrive as blockchain technology continues to evolve?
Oh, what a practical question, really. By this stage, we can already see that blockchain is no longer a technology that businesses can afford to evaluate solely from the lens of experimentation or market speculation. No, blockchain as a whole has matured into a strategic business consideration that influences corporate governance, regulatory compliance, digital transformation, and competitive positioning. And so the question, like you said, is what are then these strategic, you know, considerations and how should businesses position themselves? Well, the first is that you must be a company that can easily adaptability, because it would strategic adoption or even strategic adaptability will help you as an organization, because if you're able to, okay, let me say it this way: businesses that are able to embed compliance, or businesses that are able to integrate legal and regulatory considerations from the beginning of their product development are better able to withstand any commercial reality that may come their way in the general observance of business operations. And so for many years, you see that in the past, compliance was treated or addressed shortly before launch or immediately after launch or even years after the product has launched. But you can see now that that approach is increasingly difficult to sustain as regulators across major jurisdictions continually strengthen oversight of digital assets and blockchain-based services. Governance should likewise be viewed as a strategic asset rather than an administrative obligation, because effective governance will establish clear decision making processes. It will establish accountability. It will allocate responsibility. It will help manage conflicts of interest where they arise across the entire organization and even amongst many stakeholders. And so within a blockchain ecosystem, your governance will extend naturally beyond internal corporate structures to include protocol upgrades, treasury management, validator participation, token holder engagement, etc. Another important strategic consideration is organizational readiness. As we said earlier, compliance by design. Blockchain implementation is not solely an information technology initiative. No, it requires collaboration between legal advisors, software engineers, cybersecurity professionals, finance teams, etc. And so by bringing all of these independent teams and experts into your product build from the beginning, you are able to embed such compliance requirements or such concepts that help you or that ready your organization for any shift the law might take. Businesses should also adopt a measured and incremental implementation strategy. So rather than trying to implement enterprise-wide strategy where you're dealing with every single thing at the same time, that unless you're a very, very big organization or institution that can handle such an enterprise-wide change, it is not advisable. Most smaller organizations will buckle under that pressure. So it is important that you adopt a measured and an incremental implementation strategy where it's like, okay, you can implement or you can comply department by department progressively. That way, before you know it, you are completely compliant. And also, as a blockchain ecosystem continues to evolve, adaptability, like I mentioned earlier, will become an increasingly valuable competitive advantage because these regulatory frameworks are developing faster than they used to. And even while the technology itself is developing, the regulatory requirements, the regulatory frameworks are also developing in time with them these days. And so, as technical standards continue to mature, as these regulatory frameworks continue to develop, your business must be able to adapt. But first of all, before you're able to adapt, before you're able to adapt, you must have compliance embedded into your product design, such that no matter which way the law swings, no matter which way the technology evolves, your core operationalities or the core functionalities of your business is able to withstand any wave that comes with it. Trust also remains a defining currency of the blockchain economy. And although blockchain technology was originally conceived as a mechanism for establishing trust through decentralized systems, commercial trust extends far beyond cryptographic security. Customers, investors, regulators, commercial partners evaluate whether an organization demonstrates transparency, accountability, strict or sound corporate governance, operational resilience, and responsible stewardship towards digital assets. And so businesses that consistently demonstrate these qualities will strengthen their reputation naturally, will attract investment, and will even establish enduring commercial relationships. Trust, therefore, is not created by blockchain technology alone. It is earned through responsible business conduct, supported by appropriate governance and compliance frameworks. And so, but perhaps the most strategic lesson here is that blockchain should not be viewed as a destination, but as part of a broader process of digital transformation. Blockchain technology, will continue to evolve alongside developments in artificial intelligence, digital identity, tokenization, cybersecurity, and data governance. And so, organizations that remain informed, that invest in internal capability and continuously reassess their governance and compliance frameworks will be better prepared to handle any wave that comes with the law. And so, having explored these technological foundations of blockchain, the legal principles governing digital assets, and the evolving international regulatory landscapes, the commercial realities of operating blockchain businesses, and the strategic considerations necessary for long-term success, one final question remains. What overarching lessons should modern businesses take away from the rapidly evolving landscape? And it is to these reflections that we now turn in our concluding remarks, because I think that we have basically covered much of everything, if not everything, related to the legal, the commercial, and the regulatory aspect and reality of blockchain and the cryptocurrency technology. Thank you very much.
Wow. Blockchain and cryptocurrency technology have actually progressed far beyond the realm of emerging innovation. We have seen that they indeed sit at the intersection of law, commerce, and technology, influencing how businesses raise capital, structure transactions, manage digital assets, and build trust in an increasingly digital economy, just as Barrister Norma has elaborated on this evening. And we have also seen throughout this discussion that technological innovation alone is not enough. Sustainable success depends on understanding the legal character of digital assets, navigating evolving regulatory frameworks, establishing sound governance structures, managing commercial risk, and embedding compliance into business strategy from the outset, not at any other point. Now, responsible blockchain adoption is increasingly recognized as requiring transparency, accountability, governance, and compliance alongside innovation. As Speaker kept emphasizing that for modern businesses, regulation should not be viewed as an obstacle to innovation, but as framework that promotes confidence, protects market participants, and enables responsible growth. Organizations that invest in strong governance, thoughtful corporate structuring, effective risk management, and proactive regulatory engagement will actually be better positioned to attract investment, build lasting stakeholder trust, and compete in a rapidly evolving global marketplace. Ultimately, the question is no longer whether blockchain will influence the future of business, because it already is doing just that. The real question is whether businesses will be prepared to engage with that future responsibly, strategically, and with a clear understanding of the legal, regulatory, and commercial realities that will shape its success. Now, those who embrace innovation with discipline, foresight, and integrity will be best placed not only to adapt to the digital economy, but to help define it. I I truly believe I speak for every single person on this call when I say that this session was really an insightful one. And as we bring today's session to a close, I hope you are leaving with a deeper appreciation of the legal, regulatory, and commercial realities shaping the blockchain ecosystem and just how businesses can position themselves to thrive within it. A very, very special thank you to our speaker, Barrister Norma, for sharing such insightful and practical perspectives on this important topic. Our speaker really did justice to the subject. My expertise has undoubtedly enriched our understanding of this rapidly evolving space. Thank you so much to everyone as well, everyone who tuned in. Thank you so much. We are confident you gained value for your time, and we look forward to welcoming you to our webinar for next month. Keep an eye out on our LinkedIn page at Adun Legal for our theme for next month, because it's definitely one you should look forward to. Thank you so much, everyone. Until next month during our next webinar series.